Hello everyone. So we will be beginning with ICJ decisions, right? Article 59, I have told you already what is Article 59. The court may have jurisdiction to decide cases in which parties agree to appear before the court on their own behest and agree to be bound by the decision of ICJ. That means the court may have, okay, may as a word denotes possibility. So here shall word is not used, okay, but may is used because it is possible, it might happen, okay. So the court may have jurisdiction, that means not compulsorily it will have jurisdiction to decide cases, but only if the parties to the dispute themselves have an agreement that okay, we will be going to this particular court of ICJ for our dispute for the resolution, and वी विल ऑल्सो बी बाउंड बाय इट, बिकॉज हम खुद से अग्री करके वहाँ जा रहे हैं, उस कोर्ट को जुरिस्डिक्शन प्रोवाइड कर रहे हैं, तो वो जो भी डिसीजन होगा ऑफ कोर्स इट वुड बी इन फेवर ऑफ वन एंड अगेंस्ट द अदर पार्टी, तो वट एवर इट इज़ वी विल बी बाउंड बाय इट. सो बाउंड होने का भी अग्रीमेंट उनको करना होता है, ठीक है. Article 59, what it states, I have told you, the past decisions of ICJ are not binding. I had already explained you the concept of Supreme Court and precedents. Okay, so it is not binding. ICJ does refer to its past opinions when deciding new cases. It tends to examine its previous decisions, determine which cases should not be applied, and rarely departs from the relevant case law. Case law means whatever precedents have been of ICJ. Although ICJ's decisions are not binding, except on the parties to the dispute if they agree to be bound by it. But the ICJ, the court itself, refers to its past decisions if there are some similar circumstances, and then only it finds out that what all should not be applied, which are not matching to the circumstances or the subject matter in issue of the dispute. If it is not matching, of course it would not be applied. The same kind of decision cannot be given again, right? So in that sense it should not be applied. The court may also be a forum if provided for in a treaty between parties, and it is compulsory to refer to court with regards to certain disputes. So it can be a forum means the court of law, basically. Forum is the court of law. It can act as one if it is provided in a treaty that if any such dispute arises in the future, in treaty itself it is written that whatever are the contents of that treaty, and in what manner the states have to perform if they sign this treaty, and below that in the treaty itself it is given that if there is a dispute between two or more nations regarding the subject matter of the treaty or anything related to it, then that dispute will be referred to ICJ and it would be binding. And if it says so, then it means that for such dispute it is mandatory to approach the ICJ. Okay. अब इसका एक और you can say a kind of फायदा or benefit is that if you go to like two or more nations के बीच में dispute है, the same private international law would come into picture, where there will be conflict of laws, the conflict of jurisdiction, and you would have to choose that which one should be applicable. Both the countries will want their own respective laws to be applicable on them, which is not possible because the other one is not in the jurisdiction of the country, right? So again choice and conflict would come into picture. So ICJ is one which works on the international plane. It will not look into any country's particular rules and principles of domestic laws, but it will regulate as per the treaties or conventions that they have signed and what all manner should have been adopted by them, which is not so done, that resulted in the dispute. Okay, so that may be one benefit of referring the matter to the dispute, and if it is so written in the treaty, then the manner of the treaty has to be followed, because again treaty is an agreement which is binding on the parties. The court may give advisory opinions, that is, it can also render its advice. Advisory opinion is advice. Under 65 to 68 articles, 2 countries, these are not binding. Any advice or recommendation given by any commission body for that matter also is not binding, because by word itself is binding. Sorry, by word itself it's advice, but merely referrals to understand the point of law on the matter. For suppose if somebody is seeking the opinion of ICJ on a particular subject matter or law point कि अगर ये situation हो तो आपका opinion क्या रहेगा, है ना, how would you deal with this matter or what would you do ahead with this. So they are merely referrals, okay, to understand. Like for suppose if I ask you that what is your opinion on this article 59, right? So in that sense, whatever you have understood or whatever repercussions you feel that it would follow, right, all that would be given by ICJ if it is asked so. So, and the recommendations on a certain point of law is also seeked by a particular nation or its government, because they want to know that what's the interpretation or understanding of the court in relation to that point of law, so that they can act accordingly, and whatever their act or conduct is, that in any way does not go against the law, okay, so that they will not be looked upon badly or as a negative image on the international front. Article 38 mentions judicial decisions as a subsidiary means that we know there are many who feel a departure from the current system is necessary. However, these are the prevalent sources. Now these are whichever we did, these were the present sources of international law. Many feel that they should be changed or altered a little, because now they have become with the time outdated or obsolete. International human rights pose a variety of questions. Under the framework of international law, there are various problems related to enforcement and sanctions regarding to human rights. Now, I think the basic idea of human rights we all know, the rights or the basic entitlements which any human being is should be given by virtue of him being a human. उसके ह्यूमन होने की हैसियत से जो कुछ बेसिक राइट्स हैं या प्रिविलेजेस हैं या फैसिलिटीज़ हैं जो उसे देनी ही देनी चाहिए, दे आर कॉल्ड ह्यूमन राइट्स. वी हैव डिड वन फुल चैप्टर ऑन दिस. Second World War had a profound impact on development of HR, as there was a need for a system to give rise to protection. This led to a wide spurt of activism and literature on the same. So Second World War, of course it was on the international plane. That's why on international level only the violation of human rights were done at a large scale, because it involved a lot of lives, innocent people lives which have gone, they were captured and all such things. Also to protect it, first of all it will be developed, right? You develop or codify something and then only you will be able to protect it, right? So you first recognize that there are some human rights which have to be in existence, they have to be developed accordingly, and of course once they are developed or codified, you have to protect and maintain it and follow it, right? So all that need was felt after the impacts of Second World War. Peace Palace Library is in Hague, Netherlands, one of the oldest libraries dedicated to international law. It has collected international law publications. That means largest library है, oldest है. So इसके पास international law की library है, तो of course उससे related publications होंगे. The main objective is to service the institutions residing in Peace Palace, including ICJ, Permanent Court of Arbitration, Hague Academy. It is open to all scholars and students. Now the key inventions and treaties promoting and protecting HR international sphere. Article 4 of ICCPR states that there are certain rights that are non-derogable and constitute a special place in hierarchy of rights. Non-derogable means you cannot no matter what happens, you cannot derogate, you cannot go in contravention to such principles, because they are basic to be given and they constitute a place in the hierarchy of rights. The right to life, freedom, thought, prohibition of slavery, framework of customary international law like torture, genocide, slavery, non-discrimination. These have become inalienable rights that do not require any specific treaty to be given effect to. That means inalienable means you cannot separate it. Since these are human rights, so you cannot separate these facilities or rights from the people who are human. By virtue of being human, these cannot be separated from them. And derogable means you cannot derogate or violate or go against or take any action that goes against the protection of these rights. Okay, and if you see, we have, if I talk about our Indian Constitution, then we have right to life, freedom of thought, prohibition of slavery, torture, prohibition, principles of non-discrimination, right? These are what? Fundamental rights if I talk about, and also the basic human rights in India. Then we have UDHR, which is the very famous, I think everybody is aware of it. Liberty of a person, equality, prohibition on torture, socio-economic rights, right to work, equal pay, right to social security. That means in the society, everybody has a sense of security as being the members of that society or that nation in particular. Okay. So these are also in FRs, or this one is in DPSP also in our Indian Constitution, right? Now you can do one thing, that as I have said that these are in Indian Constitution, you find out the articles of these, okay, and do let me know in the comment section. UDHR is not a binding document per se. There have been many instances where it has been referred to by cases of ICJ, and is an extremely important document for purpose of international HR. So as I said, anything on the international plane is a weak law. Why? Because it is not binding per se. Okay, because of the fact that every state is sovereign in itself. So this is also not binding, but this does not reduce its importance. Then we have Vienna Declaration and Program of Action, emphasizing that all HR were universal. That means available to all the human beings across the globe. Indivisible, cannot be divided, it cannot be derogated. Interdependent, interrelated, means they are interrelated to each other. For example, the prohibition of slavery is some or the other way interconnected with the right to life, and right against torture is also connected with right to life. Yes, so that's why they are interrelated. Then we have UN High Commissioner for HR, who would principally be responsible, principally means mainly responsible for UN human rights activities. High Commissioner can make recommendation to other UN bodies and coordinate between them. So his work was to ensure the coordination between other UN bodies and to ensure that the human rights activities as far as the United Nations as a body, as an organization is concerned, that is being conducted smoothly. Then Convention on Prevention and Punishment of Crime of Genocide. Genocide is anyway, if you find this word written side, it means killing. Geno means genes, killing. That means a huge mass of people. You kill a huge mass of people, that is genocide. So the convention was to prevent it, and if it is taking place, then the punishment for doing that. Then we had International Convention on Elimination of All Forms of Racial Discrimination. Racial discrimination, I think you know what it means, to discriminate on the basis of the skin color of people. So to eliminate all such forms of discrimination. Read with the provisions of UDHR give rise to a host of, means a collection of enforceable rights. Enforceable means which can be enforced in a court of law. Means if it is violated, then the concerned person whose right is violated, he or she can approach the court of law टू एनफोर्स द सेम, कि मेरा वॉयलेट हुआ है, अब आप उसको एनफोर्स करवाइए, मतलब मुझे वापस से वो राइट दीजिए, एंड जिसने वॉयलेट किया है उसको जो भी पनिशमेंट प्रिस्क्राइब्ड होगी इन द लॉ ऑफ द कंट्री वो दे दी जाएगी. कस्टमरी इंटरनेशनल लॉ, नाउ यू नो व्हाट इट इज. Then Commission on HR, that is Human Rights Council since 2006, which looks into the matters of HR. Human Rights Council is continuing the work of Commission by broadening its framework, by spreading its area over a wider framework. So whatever the work was of the Commission, that is now taken up by the Council, and the framework is also expanded. Means the areas on which the Commission worked, उससे ज़्यादा एरियाज पर अब ये काउंसिल वर्क करती है. It has faced criticism on its political selectivity and failure to objectively review the issues in certain countries. That means now, since we say political selectivity means it selects some of the particular countries or political mechanisms in that particular country, और किसी कंट्री के खिलाफ वो कुछ नहीं बोलेगी, तो आप कह सकते हो वो पॉलिटिकल प्रोपोगेंडा कर रही हैं. कुछ कंट्रीज़ को सेलेक्टिवली बहुत ज़्यादा ब्लेम कर रहे हैं, कुछ को चाहे वो जितना ही गलत करे, जितनी जेनोसाइड कर दे, उनको कुछ नहीं बोला जा रहा है. सो दैट इज़ ऑब्जेक्टिवली रिव्यू द इशू इन सर्टेन कंट्रीज. Given the primacy of human rights even in domestic legislatures all over the world, it is almost no surprise that international HR law is possibly given such a high degree of importance in international law. That means in domestic laws of almost every nation across the world, there is a huge importance and recognition of the human rights, because we have to provide some basic amenities, facilities or rights, privileges to the citizens of each country, right, because of the virtue of them being a human. That's why human rights has gained great value and significance at each nation. So that's why it is even a more great degree or a greater degree of importance in international law. Erga norms, generally human rights violations are dealt with by state or country in which they occur. That means wherever the violation of a particular human right of any person has occurred, then the according to the domestic law of that country, whatever the suitable remedy is, it will be awarded. However, there are certain HR established under treaty that may constitute erga norms obligations for the state parties. That means they may not be in the domestic laws, but they have to follow it because they have signed the treaty and acknowledged themselves to be bound by it. So that is known as erga norms obligation for the parties. This means that some violations are so grave that any state or country may take action regardless of whether they occurred in their jurisdiction or not. So generally what happens is the domestic law of a particular country is only applicable in the jurisdiction of that country, not beyond its territorial limits, right? We know that very well, but there may be some very grave situation in which you don't have to wait to have the jurisdiction on that matter, but you can directly proceed with it and prosecute the person who violated it to provide the remedy whose right was so violated. All states have a shared interest in elimination of such grave violations. Shared interest means their interest or their concern is common and shared, that is we should avoid such grave violations and create such a deterrence so that it is not repeated in future, right? Because if such violations keep on repeating, there is no point of any law unless there is a deterrence effect to that extent. So the interest is common to protect. Every government of every country has the responsibility and duty to protect the interests and welfare and to give protection to its citizens, right? So if there is a grave violation against a community or a great number of its citizens, then it is the concern to protect it, and hereby all the other nations also have the common interest. That's why it is written shared interest to eliminate such grave violation. That's why even without jurisdiction they can proceed to act against it. One of the most empowering features of international law is that it does away with borders and limitations of a domestic body. That is here of course the rules and regulations. The domestic legislature के बॉर्डर का बॉर्डर और लिमिटेशन क्या होगा, उसका टेरिटोरियल लिमिट उसके आगे जाता है. मीन्स वी आर नॉट कंसर्निंग और वी आर नॉट लिमिटिंग आवरसेल्व्स कह रहे हमारा तो टेरिटोरियल लिमिट इतना है तो अब हम इसके बियॉन्ड लेजिस्लेट या जुरिस्डिक्शन नहीं एक्सरसाइज कर सकते. ये जो लिमिटेशन या रेस्ट्रिक्शन है किसी भी स्टेट की या किसी गवर्नमेंट की उसको एलिमिनेट करता है. That is the empowering feature. Empowering means why empowering? Because it empowers, it gives power to the government of that state to act even beyond its territorial limits. So in that situation, that restriction of jurisdiction is not applicable. It has been done away with by the international human rights law, and allows the international community to seek an active role to protect rights of citizens of other countries. अपना तो करना ही करना है, अपना तो सिटीजन्स के राइट को प्रोटेक्ट करने की रिस्पॉन्सिबिलिटी है ही, साथ में हैविंग बीइंग सेड दैट दे हैव शेयर्ड इंटरेस्ट, सो दे कैन ऑल्सो कोऑपरेट टू प्रोटेक्ट द इंटरेस्ट ऑफ सिटीजन्स ऑफ अदर नेशंस. ओके, नाउ इंटरनेशनल लॉ, म्यूनिसिपल लॉ. Can international law be directly applied in the domestic jurisdiction? The interplay between municipal international law is complex. Some authors, interplay means the link between these two. Okay, one is on the international level which is weak, which is not binding generally, and the other one is domestic, which applies throughout the territory of that particular nation of which it is the law, and it is binding, right? So there is a contrast between these two streams of law, as we have already discussed in the first few lectures of this unit only, right? So here the question is that can it be directly applied? Some authors believe that international law and law of domestic jurisdiction, that is municipal law, do not intersect. Means they do not they do not have a common meeting point. To say intersect means, suppose this is the line of municipal law, then this is the line of international law. Intersect means there may be a one point where they have some common common agenda या common principles. ऐसा कुछ नहीं है. They do not intersect, but they are totally different entities. As I have told you, there is a contrast between the two, right? They cannot affect or overrule each other. Since they are different entities, they don't have any law or rule in common, so there is no question of overlapping or overruling each other. In practice, it seems that this does not hold true. Why? Because in practice, the treaties which the parties have signed or acknowledged themselves to be bound by it, they have to ratify it, right? तो overlapping तो आ गई ना. आप सोचो, अगर हम किसी पर्टिकुलर ट्रीटी के प्रिंसिपल्स अपने नेशन के डोमेस्टिक लॉज में इनकॉर्पोरेट कर रहे हैं तो इंटरसेक्शन या कॉमन मीटिंग पॉइंट तो हो गया, राइट? दूसरी बात, देयर मे बी अ सिचुएशन वेयर even if the country is party to that treaty, but according to the circumstances or predicament or situation of the country, it has deviated a little from that principle of the treaty, okay, to adapt the principles as per the situations of its own country. उन्होंने थोड़ा बहुत adaptation किया है, modification किया है, right? So यहाँ पर हो सकता है कि ओवररूलिंग हो जाए. ओवररूल का मतलब है कोई इंटरनेशनल लॉ कोई बात बोल रहा है तो म्यूनिसिपल लॉ कोई और बात बोलेगा, ठीक है, उसी सेम पॉइंट पर. तो अगर ऐसा कुछ ओवररूलिंग हो जाता है तो फिर क्वेश्चन बनता है कि हम किसकी बात माने, इंटरनेशनल लॉ की या म्यूनिसिपल लॉ की. ये एक एग्जांपल दे रही हूँ मैं. ओवररूलिंग में ये क्वेश्चन आता है कि हम किसकी बात माने. व्हेन ऑन द सेम इशू or point of law there are two different opinions, okay, and then it is confusing that which opinion is to be considered correct or binding. Fine. because it's law, so the binding force has to be attached to it. Some principles with respect to conflict are: municipal law cannot serve as a defense to breach of international law. That means if you are breaching any of the principles of international law, then you cannot use that मेरी कंट्री का लॉ मुझे परमिट करता है कि मैं इंटरनेशनल लॉ ना मानूं, ऐसा नहीं बोल सकते, ठीक है, क्योंकि इंटरनेशनल लॉ इज़ व्हाट, लॉ ऑफ ऑल द नेशंस कंबाइंड, एंड म्यूनसिपल लॉ इज़ लॉ ऑफ अ पर्टिकुलर नेशन, तो ऑब्वियसली उसका डोमेन ज़्यादा हो गया, राइट. सो यू कैन नॉट से दैट द म्यूनसिपल लॉ का कोई भी म्यूनसिपल लॉ, बहुत सारे लॉज होंगे एक नेशन में, कोई भी एक लॉ का कोई भी प्रिंसिपल मुझे परमिशन देता है या इम्यूनिटी ग्रांट करता है कि अगर मैंने कोई इंटरनेशनल लॉ का प्रिंसिपल वायलेट कर दिया तब भी मेरे अगेंस्ट कोई प्रोसिक्यूशन, कोई प्रोसीडिंग नहीं होगी. सो दैट डिफेंस कैन नॉट बी यूज्ड, ठीक है. इसका मतलब क्या है कि आपने जानबूझकर इंटरनेशनल लॉ के प्रभाव को, उसके बाइंडिंग फोर्स को, या उसको साइन करने के बावजूद आपने क्या किया, उसको बिल्कुल ही ओवर रूल करने का आपका इंटेंट था, राइट. यू आर डायरेक्टली अफेक्टिंग इट. आपने एक ऐसा लॉ बना दिया अपने नेशन में कि आप किसी भी ट्रीटी या प्रिंसिपल को टोटली ओवर रूल करने का इंटेंशन रखते थे बाय मेकिंग दैट लॉ, एंड नाउ हैविंग मेड दैट यू आर यूजिंग इट एज अ डिफेंस अगेंस्ट द वायलेशन ऑफ प्रिंसिपल ऑफ इंटरनेशनल लॉ. सो ये आप नहीं कर सकते, ठीक है. Neither one can say that their consent to a treaty has been invalidated, means it is invalid by way of a change of its municipal law. That means now there is a change in the situation. With situation, the situation and time law changes. It is a dynamic concept, right? So now there is a change in the municipal law, and I have signed a treaty way back 2 or 3 decades back, right? So now because of the change in time हमारा municipal law change हो गया, तो अब जो है हमारा इस पॉइंट पर हमने जो कंसेंट 20-30 साल पहले दिया था वो इनवैलिड हो जाता है, ठीक है, क्योंकि हमने अपना लॉ चेंज कर लिया है विद टाइम. ये भी नहीं हो सकता. ये क्लियरली क्या दिखाता है कि आप इंटेंट कर रहे हो, द लेजिस्लेचर ऑफ दैट नेशन इंटेंट्स टू डायरेक्टली अफेक्ट और ओवर रूल द इंटरनेशनल लॉ, एंड यू कैन नॉट डू दैट. ओके, सो दीज आर द कंट्रास्ट्स. ICJ has stated that lack of domestic legislation cannot be brought up as a defense if there is an international obligation on the state not to do a certain act. अगर किसी भी ICJ रूल्स या UN के जो प्रिंसिपल्स होते हैं उसमें लिखा हुआ है, या कोई भी जो कन्वेंशंस बनी है उसमें कुछ सर्टेन प्रिंसिपल्स लिखे हैं, बट द डोमेस्टिक लॉ on that subject, on that issue is absent in a particular nation. So absence of municipal law also cannot act as a defense, ठीक है. If according to that treaty or international law it was obligation on the state to not to do that act, ठीक है, तो आप ये नहीं डिफेंस कर सकते कि जी हमारे नेशन, मतलब हमारे नेशन का तो कोई लॉ ही नहीं है जो मुझे ये काम करने से रोके. तो ठीक है, कोई लॉ नहीं है तो आई एम नॉट बाउंड, आई एम नॉट गिल्टी, राइट. इंटरनेशनल लॉ इज प्रेवलेंट ओवर द डोमेस्टिक लॉ, हाउएवर दैट डज नॉट मीन दैट डोमेस्टिक लेजिस्लेशंस कैरी नो फोर्स. सो इन सब से आपको लग रहा होगा दैट इंटरनेशनल लॉ इज हैविंग अ ग्रेटर बाइंडिंग फोर्स, तभी डोमेस्टिक लॉ है नहीं है या वो जो भी बोल रहा है उससे फ़र्क नहीं पड़ रहा, इंटरनेशनल लॉ में हम डिफेंस नहीं ले सकते, राइट. बट दिस डज नॉट मीन दैट डोमेस्टिक लेजिस्लेशंस का कोई असर नहीं है, ठीक है. वाई आर दीज थिंग्स और दीज डिफेंसेस बीइंग कंस्ट्रक्टेड कि आप एब्सेंस ऑफ लेजिस्लेशन का फ़ायदा नहीं उठा सकते, या लेजिस्लेशन अगर कॉन्ट्ररी बोल रहा है, ओवर रूल कर रहा है, उसका फ़ायदा नहीं उठा सकते, ताकि एक जो इंटरनेशनल डोमेन में लॉ बनाया गया है उसकी रिस्पेक्ट इंश्योर की जा सके बाय ऑल द नेशंस अक्रॉस द ग्लोब. अदरवाइज इट इज़ वेरी ईजी, क्योंकि आप अपने आप में सोवरेन हो, आप कोई भी लॉ अपनी कंट्री में बना सकते हो, कोई आपको रोक नहीं सकता, राइट. आपने कोई लॉ बनाया कि ये एक्ट आप कर सकते हो, बट ऑन द इंटरनेशनल डोमेन इट इज़ नॉट अलाउड फॉर द स्टेट टू डू, राइट. तो आप टोटली अफेक्ट कर रहे हो एप्लीकेशन ऑफ दैट लॉ. सो ये सब चीज़ें इसलिए अवॉइड करी गई हैं ताकि जो लॉज एक कोऑपरेशन, कोऑर्डिनेशन, पीस, हार्मनी अक्रॉस द ग्लोब इंश्योर करने के लिए बनाए गए हैं, उसको कुछ रिस्पेक्ट या कुछ कंसर्न दी जा सके, रिकग्निशन दी जा सके. अदरवाइज इट्स ऑब्वियसली ऑलरेडी हैविंग अ वीक बाइंडिंग फोर्स बिकॉज ऑफ द सोवरेनिटी ऑफ नेशंस. तो वो बिल्कुल ही लॉस्ट हो जाएगा और कोई मतलब नहीं रहेगा इंटरनेशनल लॉज या ऐसी कोई स्ट्रीम भी बनाए रखने का. ठीक है. International treaties require that countries adopt domestic legislation in line with international obligations it has already agreed to. As I have told you कि कुछ इंटरनेशनल कन्वेंशंस होते हैं कि अगर आपने उस कन्वेंशन के पार्टी बने हो तो आपको अपने नेशन में उस लॉज को, उस प्रिंसिपल्स को इनकॉर्पोरेट करना पड़ेगा. सारे नहीं कर रहे हो कोई बात नहीं, थोड़े या जो बेसिक प्रिंसिपल्स हैं उस कन्वेंशन या ट्रीटी के उसको आप अप्लाई करो. ज़रूरी होता है अप्लाई करना. ठीक है. इंडिया में भी काफ़ी ऐसे लॉज हैं, एक्ट्स हैं जो कि इंटरनेशनल कन्वेंशंस टू विच इंडिया इज़ अ पार्टी उसके लीव में बनाए गए हैं. ठीक है. यू कैन सर्च फॉर इट. ओइंग टू सच रिक्वायरमेंट्स देयर इज़ अ ब्लरिंग ऑफ डिस्टिंक्शन. मीन्स बहुत ब्लर लाइन है, धुंधली सी जिसको बोलते हैं, नॉट क्लियर डिस्टिंक्शन between international and municipal law, and domestic courts have also started analyzing international obligation of states in domestic disputes. That means कि जो domestic courts होते हैं which are in the particular nation's domain only, उन्होंने भी एनालाइज करना शुरू कर दिया है that what is the international obligation of our state as per the international law. ठीक है. dispute भी domestic है और कोर्ट भी डोमेस्टिक है, बट वो भी इंटरनेशनल लॉ को रिस्पेक्ट देना शुरू कर चुके हैं. ठीक है. नाउ दिस एप्लीकेशन वी विल बी टेकिंग अप इन द नेक्स्ट वीडियो.